Hello, and welcome to Other Voices Online, a monthly conversation for and among activists. Other Voices is brought to you by Peninsula Peace and Justice Center. I'm your host, Paul George. I was thinking of calling this episode of Other Voices our Halloween special, because when you start to think about what the Supreme Court might be up to in its new term, it's a pretty scary stuff. Just as a reminder, in the last term, the Supreme Court, now dominated by 6 conservatives, 3 of them appointed by Donald Trump. Last term, the Supreme Court stripped women of their constitutional right to an abortion, while at the same time they expanded the rights of gun owners. The conservative majority also imposed severe new constraints on the power of regulatory agencies to confront climate change, and further dismantled the wall of separation between church and state. Some of these issues will be back, some will have some new ones. Joining us to take a look at this and do a little tea leaf reading, I'm really pleased to be joined again by Judge LaDoris Cordell. Judge Cordell is a retired judge of the Superior Court of California, a former member of the Palo Alto City Council, and former Independent Police Auditor for the city of San Jose. She is still very much a tireless community activist dedicated to making good and necessary trouble. Judge Cordell was the first female African-American judge in Northern California and the first African-American Superior Court judge in Santa Clara County. She has received numerous awards and prizes for social activism and breaking race and gender barriers, including the Rosebird Memorial Award from the California Women Lawyers and the Rosa Parks Ordinary People Award from the NAACP. And I just learned that she's getting an award tonight at 8 p.m. from an organization in Sacramento. So we're going to wrap up by 7:55 at the latest this evening. And I must also mention that Judge Cordell is the author of the recently published memoir, Her Honor, My Life on the Bench, What Works, What's Broken, and How to Change It. And it's now out in paperback. Judge Cordell, welcome back to Other Voices. Thank you so much for taking the time to be with us tonight.
Thank you so much, Paul. And I am so pleased to be in conversation with you. It's always interesting.
Well, let's hope I can keep the streak going. We can both keep the streak going. Before I get into some of these particular cases that the court is going to be considering in this term, I want to start with the personnel on the court. And of course, we have a new justice in Justice Ketanji Brown Jackson. Can you give us your take on her appointment and what you expect her impact on the court to be?
Sure. But before I do that, I just want to have a disclaimer. I am not an expert on the United States Supreme Court. I can certainly give my opinion, which is what I will do this evening. But I'm not the person, if people have questions, to get into the technical details or history of the court, because that's not my area of expertise. So that being said,
okay,
I also when we discuss the cases that are before the court, I have made several notes here because as I said, I'm not an expert, and I just want to make sure that people understand when I look down occasionally, because I have some notes. All right, so Ketanji Brown Jackson, the first African-American woman to sit on the United States Supreme Court. So that's remarkable in and of itself. And for those of us, and I'm assuming your listeners and watchers saw the confirmation hearings and saw the racism, the sexism, the condescension from the conservative members of the Senate when they questioned her, and at the same time saw her composure, her taking the high road and answering the questions clearly, forthrightly, made us all proud. So she joins the liberal wing of the Supreme Court. As you noted, there are 6 on the conservative side and 3 on the liberal side. All 3 are women, 1 Latina, 1 African-American, and 1 who is Jewish. We're going to see for, I don't know for how long on the court, we're going to see a whole lot of 6-3 decisions, meaning these 3 liberals are going to be dissenting, sadly, I believe, for quite a while.
Yeah. One of the things that I've gotten from reading so much about the Supreme Court, as I've been doing recently than I have before, is that there is the dissents that they write. The three liberals who are now in the minority do play an important role in the future. Could you explain that a little bit?
Sure. Absolutely. So it is the case that through history, justices who have written dissents have written beautiful dissents, and over time, over the passage of time, those dissents become majority opinions much further down the road. So, and actually there's a book recently out called The Great Dissenter, and it's about Justice Harlan, someone you wouldn't expect because of his background to have been a dissenter in a very big case before the Supreme Court many years ago regarding race. So it can happen, it does happen. And that's why I think you will find the dissents written by the three to be instructive, to be beautifully crafted, and I think well positioned so that hopefully one day when this court becomes more reflective of America in terms of issues and attitudes, these dissents will then take on the majority view.
Boy, you know, that's such a good point to make, that this court, as it's currently constituted, comes nowhere close to representing America. I think the reaction to the Dobbs decision shows that it flew in the face of the opinion of a vast majority of people in this country.
Right. And you know what happened as a result of the Dobbs decision, and it isn't just that, but it was really kind of was the tipping point, is the disapproval of the U.S. Supreme Court is at its highest level ever. So there are, at least the recent poll, 58% of Americans disapprove of the court. And a whopping 47% of Americans disapprove of the federal courts in general, or don't trust them. It's a trust issue. So there's much to bemoan about what direction this court is going, and it's directly a result of these decisions that they're making that do not reflect where Americans are today.
Absolutely. Well, let's get into some of these cases and get out our crystal balls and see what's coming up. I want to start with one that was argued this week, and in which Justice Jackson got a lot of attention for some of the remarks that she made, and that's Merrill versus Milligan, which is a redistricting case brought by Alabama. And they're challenging they're using Section 2 of the Voting Rights Act to challenge being ordered to redistrict to better reflect the population in Alabama. Did I kind of sum that up correctly?
That's good. So we're talking about the Voting Rights Act of 1965. The conservatives on the Supreme Court have just been itching to ditch the entire act, and they have been doing it piece by piece. So Justice Roberts wrote a majority decision where he basically gutted Section 5 of the Voting Rights Act. Section 5 said very clearly that states that have a history of discriminating against people of color, and specifically African Americans, in their voting laws, they have to get a pre-clearance. They have to be cleared by the court before they can change their voting rules. And of course, the reason for this is the long history of discrimination and racism. So Justice Roberts in that case gutted it, and the section and his rationale was, oh, we don't have racism anymore in America. And he said this right after Barack Obama was elected. See, we got a person of color in the White House, so we don't need Section 5. Wrong, but that's what he did. Then the court weighed in on one part of Section 2, and they gutted that. And that Section 2 deals with primarily gerrymandering, which deals with redistricting, where those lines are drawn, will result in political voting power. So Section 2, the first part they gutted, was basically said that people of color who are saying we're not being fairly treated by this gerrymandering, their ability to bring individual lawsuits to attack that has been wiped out. The court said, no, you can't do that. So there's another part of Section 2 left. And this is the one that deals with redistricting. And the issue there is whether or not, this is Alabama, the courts basically said that redistricting is diluting the voting power of African Americans. And the court's going to look at it. And the concern is, and I think this is what they're going to do to gut that section that deals with the power of saying you can't have gerrymandering that is racist. They're going to say, I think, if you use race at all, that's just impermissible. So we're not going to allow you to challenge the gerrymandering or redistricting based upon race. So it's basically a challenge to the whole issue of redistricting that's in Section 2. Once they do that, in Merrill versus Milligan, you can forget about the Voting Rights Act. They will have wiped it out. Even though it's still on the books, they would have taken away all of the power to enforce it.
And the conservatives in pursuing this, just like you mentioned, Justice Roberts gutting Section 5 of the Voting Rights Act several years ago, they're claiming that the Constitution is race neutral, in particular citing the 14th
Right.
Amendment.
Right.
And this is where Justice Jackson had such a powerful statement, because she kind of echoed the originalist theory language of the conservatives to point out that the 14th Amendment is by no means race neutral. In fact, it meant the opposite. Right.
So the part of the 14th Amendment deals with equal protection. And basically the court, I think the conservatives are starting to say, well, the 14th Amendment's equal protection clause is, you can't have that equal protection and then still have any kind of a racial preference at all. And this is where Justice Brown Jackson was absolutely brilliant. So I want to note, at her confirmation hearings in March, she declared herself to be an originalist. And I think the conservatives were like, what is she talking about? She's just saying that to get on the court. But what she said, and I'm going to just quote from it, what she said at her hearing, I look at the text to determine what it meant to those who drafted it. And then at this hearing, before the court this past week, what did she do? She invoked originalism. And I will quote from her once again. She said, in talking about the 14th Amendment and the Equal Protection Clause, she wrote that she said, bear with me,
Sure.
The entire point of the 14th Amendment was to secure rights of freed former slaves. And she continued, I don't think that the historical record establishes that the founders believed that race neutrality or race blindness was required. And I don't believe the conservatives had much to say after that. She was basically relying on facts, which they tend not to do because they want to get things going in a way that they want instead of relying upon what the facts are. So she gave them a lesson. She gave them a lesson about the 14th Amendment and its history.
Yeah, I also pulled a quote from what she had to say during oral arguments. So let me slip this one in.
Okay.
The drafters, she observed, were, quote, trying to ensure that people who had been discriminated against were actually brought equal to everyone else in the society. That's not a race neutral or race blind idea, end quote.
Isn't that beautiful?
It is fabulous. I am looking forward to hearing more of her. I'm just really afraid of what the decisions are going to be.
Yeah.
And as you've pointed out, the Voting Rights Act has been something that's been in the conservatives' crosshairs for a long time. The Supreme Court, even before this 6-3 majority, supermajority, has been chipping away at it, as you rightly noted at the outset. And you believe that they are going to rule in Alabama's favor here, despite
Oh, yeah.
the powerful arguments
Yeah.
by Justice Jackson.
I do, but another thing that's interesting, the Supreme Court historically has taken cases where there is a conflict among the states in interpreting a particular law or statute. And this court, the six, and when I say the court, I call them the Gang of Six. The Gang of Six is not even waiting for there to be a conflict before wading in on issues. They have designated and picked issues that they have just personal concerns about and brought them to the court instead of waiting to see if there is indeed a real conflict in interpreting the law or interpreting a statute in some fashion. So they are doing these things. Why? Because they can, because there are six of them and they can.
They have kind of a history under the Roberts Court of kind of really going after finding cases that they want brought.
That's exactly.
Going back to Citizens United, they essentially invited that that case to come before so that they could wipe out campaign finance.
Exactly. Right. And look what Clarence Thomas has done. In a dissent in the Dobbs case, what did he do? He said, well, I think the court needs to look at same-sex marriage. Well, there is no conflict. The court made a statement, issued a ruling that said it is constitutional and legal. And now there's still no conflict, but he's saying, so what? Let's see what we can do. And he was basically inviting someone to challenge the same-sex law, say in a state, to bring it before the Supreme Court. This is how they're operating. It saddens me. It frightens me. And as you noted, they have more cases now on the docket. And underlying the cases, the others, there were a total of four cases that have race underlying them all, which is really interesting. The fifth one is one that deals with gay rights. That's a little different, but there are at least four where race is underlying all of them. And my fear is that these Gang of Six, they want to be able to rule that the Constitution does not allow any consideration of race, regardless of history, regardless of the purpose, or regardless of the goals. And if that were to happen, that would be a tragedy for this country.
One of those cases is one that you wrote about in your recent book. I'm not sure how to say this, Brackeen versus Holland.
That's correct.
The Interior Secretary.
Yeah, actually, it's Holland versus Brackeen.
Okay. Yeah, I got this from the SCOTUS blog, and apparently it's not explained, but it was Holland versus Brackeen, and Cherokee Nation versus Brackeen, and Texas v. Holland. And when they all got combined, SCOTUS blog is calling it Brackeen versus Holland. I don't know how these work, but
got it.
Why don't you explain what that's about and how that fits into this picture you're just painting?
Sure. In 1978, the Congress passed the Indian Child Welfare Act, and the purpose was to address the actual theft, removal of, and I'll call them Native Americans for our discussion, although it's called the Indian Child Welfare Act. So we're talking about the indigenous people in this country. I'll call them Native Americans for now. And it was that legislation was to address the basically taking of children and putting them with white families and basically getting Indian children away from their culture and getting them to assimilate. And this country is not unique in that happened in Australia with indigenous people and in Canada. So the Welfare Act basically has a provision that says that when an Indian Native American child is up for adoption, that first preference must be given to placing that child with a Native American family or with a tribe. That's the first preference. The Brackeen family are white evangelicals who don't like that and have basically want to adopt. They've adopted already one Native American child, and I write about that in my book, and they want to adopt the sibling of that child. And so there was an objection from the Cherokee tribe saying, no, this child is Cherokee, the child is to stay and given a first preference to be adopted within this culture. And the Brackeen said, no, you're discriminating against white people. there shouldn't be any racial preference. And for that reason, we think the Supreme Court ought to basically just throw out the Indian Child Welfare Act of 1978 and say that there can't be a preference because it's racial discrimination. So that case has now worked its way up to the Supreme Court and is on the docket. It's going to be heard on November the 9th.
Yeah, just about a month from now. Do you have a feeling, given the past history of this court, where this might go? You've already expressed your deep concern that they are trying to get rid of anything based on race, or where race is even part of the discussion.
My feeling is they will rule in favor of the Brachines and allow the adoption to go forward, and at the same time gut the act. And remember, at least one of the justices, Amy Coney Bryant, has adopted children and children of color. So my guess is she's going to, I don't think she's adopted Native American children, but I know she has at least one Black child. And so my guess is that, her personal preference is going to come in and she's going to do what she thinks is right. And that's not what they're there for. They're there to interpret the law, and the Indian Child Welfare Act has been in effect since 1978. And here we go again, where there's no conflict in the states. But what we have is a claim of reverse discrimination, and the Brachines want this preference of placing these children within their own culture to go out the door, and history be damned.
So again, that's Holland versus Brackeen, and that's due to be heard on November 9th. So keep your eyes on that one. Let's move right along here. The next one I want to talk about is probably one of the strangest ones, also affecting elections. This is not redistricting, however. This is Moore v. Harper, coming to the Supreme Court with something known as the independent state legislature theory.
Yeah.
Did you talk about that?
Sure. So expect the unexpected. I mean, and anything these folks can pull out of the hat, they're going to do it in order to try again this is a case involving undermining the Black vote. So this case is out of North Carolina. It's called Moore versus Harper. And this is where the North Carolina Supreme Court struck down North Carolina's legislature's redistricting plan for federal elections. And they struck it down because it disenfranchised Black voters. So an appeal was taken up. It is now going to be before the court. And the argument is, under this independent state legislature theory, that state legislatures are free to do whatever they want to do in setting up these districting regarding federal elections, and are free to do it and cannot be monitored or reined in by anyone, and specifically by the courts. So under this theory, they're saying we can operate as we want. The courts have no business weighing in on how we set the rules that govern these federal elections in our states. In opposition to this, every state Supreme Court justice, all 50 of them, have submitted a brief against this, saying, of course, the courts should have the ability, have the power to review these redistricting decisions by the legislature, and also to make sure that if they are discriminating against, say, Black voters or Latino voters, that they're able to fashion a remedy. So once again, underlying this is the issue of race. And now they've come up, they, meaning the people who are seeking this, are now saying that, well, there's this thing, this independent state legislature theory that says we have a right to do this. Now, I'm not an expert on this, but there is some language, I guess, that may be in the Constitution, I'm not sure, that says something that gave them the idea that, well, that's really what that means, that the courts can't tell us what to do. No one can. We're elected by the people, so we're charged with doing and taking care of this particular issue. It's very scary. On this one, I'm not so sure that the courts gang of six are going to say, yeah, let's have everyone use the independent state legislature theory. I don't think so. I think this was going to be a close one, but I could see, for example, Roberts perhaps going to the other side on this, and they need 5 votes. So I'm not sure who else might join them. Maybe Kavanaugh. I'm not sure.
The language in the Constitution that you were referring to is like one sentence that says, quote, "The manner of holding elections for senators and representatives prescribed by the legislature thereof." So that they're saying, since the Constitution says the legislature sets the rules for the federal elections, nobody else can have a say in it. And this has been tested before, I think, in some manner or other, but it's certainly a debunked idea. It'll be interesting to see what the arguments are on that one. And
Yeah.
I had actually forgotten about the 50 state justices that
Yeah,
have
the
already
Supreme Court
weighed
justices.
in on that. That's very
Right.
powerful. There's
Yes. So I don't see this one going that far. But our system of government is built on checks and balances. So of course there has to be a check on if the legislatures are going rogue and doing things that are disenfranchising people, then of course there have to be checks and balances. That's how the system in a democracy works. The folks who are trying to get this theory adopted want to throw all of that out.
Like you, I can't see justices at any level agreeing that they don't have a role or a say in this, especially this activist court. They're not going to want to give up their shot at getting into this. 2 more cases that had been combined and were now separated. Both have been brought by an organization called Students for Fair Admissions. And one is against the University of North Carolina, and one is against Harvard College of Law, I believe it is. And both of these are dealing with affirmative action policies that a lot of universities use in their admittance. And it's specifically challenging a previous Supreme Court decision called Grutter versus Bollinger, if I'm saying that right, that held that looking at race to look at a diverse student population is okay if that's not the only criteria that you're putting out there. And they are being challenged in both of these. And as I said, they had the court had previously combined these 2, but they uncombined them because Justice Jackson, the newest justice, served on the board of Harvard and very closely attached to Harvard, and she will recuse herself from that one. So they split them up again so that she could participate in the North Carolina one. Your take on affirmative action being yet again back before the Supreme Court?
Right. For 41 years, the Supreme Court has upheld affirmative action programs, and in doing so have said that race can be a factor in considering admissions. I believe the Harvard case isn't just the law school. I think it's Harvard University. So 41 years, and now this group, Students for Fair Admissions, they are Asian American students, and they are funded by one person. I blocked his name probably because he just disgusts me so much. But he's funded gives a lot of money, and the Students for Fair Admissions, there aren't any members of it, really. It's just him. And then he finds individuals who will be plaintiffs, and he has been on a journey to take race out entirely. So it's really sad to me because it's really pitted Asian American students against African American students and Latinos who are, or Latinx, who believe, as I do, that affirmative action is important to remedy the problems in the past, discrimination in the past, But this court has decided, no, we're going to take a look at this. And Harvard's a private institution. University of North Carolina is a public institution. So, and yes, they have separated them out. Justice Brown Jackson had the ethics, the morals, and the good sense to recuse herself from the Harvard case because she said, look, I could probably be fair, but I have a close connection to Harvard and I don't want even the appearance of any conflict. So for that reason, she backed out. She didn't have to do that. And as you know, with Clarence Thomas and his wife going rogue with the whole the steal, all of the lie about the election, he absolutely should be recusing himself and have recused himself from cases that deal with this issue in the election, and he has declined to do so. Shame on him. And that's another reason such disapproval and distrust of the Supreme Court is so high. So the issue before the court with these two cases is, can race be a factor in determining admissions at a private and public colleges? That is the issue. It has always been a factor to consider. And this court now has the opportunity to say, no, we're just going to take it out completely. You can't. And I think that'll be yet a very sad decision, disappointing. So my guess is yes, that they took this case because the Gang of Six wants to gut affirmative action programs too. So what the colleges and universities can do after, if I'm correct, this is they cannot consider race at all. They can look at socioeconomics. They can look at income factors, what backgrounds people come from, but that's probably going to be it, other than the standard things they look at in terms of their academic records and scores, test scores.
Yeah, and again, going back to they're searching out cases to overcome existing precedent. The I guess controlling opinion here from Grutter versus Bollinger goes back to 2003. It's 19 years ago, almost 20 years that we've been dealing with affirmative action. I think most universities thought this was settled, that as long as they didn't have just a race-only criteria, but a broad array of criteria, as you've just described, that's okay. But now this court apparently wants to take race off the list, even though they might allow some of the others to stay. So that's going to be argued at the end of this month.
Before you move on for that, I just want people to also understand that the person who coined the phrase affirmative action was John F. Kennedy when he was president. And so this wasn't something that came from a bunch of Black folks. He's the first person to actually use the phrase. And the point of it was to do affirmative things to address past discrimination. And it's on, he believed, us in the present to change things, to affirmatively take steps, take action to see that these remnants, the after side effects of the racism are somehow remedied. So there's a long history of affirmative action, and it didn't just start in the education side. It was in hiring practices, all of this. So this could start us down a road that these Gang of Six are basically could be saying, you know what, we're just going to take race out of the mix entirely, which is bizarre because this whole country was the original sin was the enslavement of Africans, and so much still needs to be done because there is so much systemic racism, and either they don't see it or they see it and they don't care. So I'm very concerned, and I think that they are, unless someone like Justice Brown Jackson can persuade her colleagues, we may see the destruction of affirmative action, at least in admissions.
Boy, oh boy. As I said, this is the Halloween edition, scary stuff.
Yeah.
Let me invite our audience to participate here. You can either type in a question by clicking on the Q&A button, and I'll try to see what's in there and get to those. We do prefer to people come on and join the conversation. So if you don't mind coming on camera and becoming a panelist for a little while, click on the raise hand button, and our director will bring you on in order that you go up. And otherwise, I will check the Q&A button. And while we're getting some people on, oh, and by the way, if you do come on, when you come back on, you need to turn your audio on yourself. We can't unmute you from this side. So keep an eye out for that. And if our
Can I just
director-
add, can I
Sure.
add one thing? And this is
Yeah.
about the affirmative action cases. I'd like all of us to just picture what that conference room is going to look like when the justices are there and they are talking about the, let's say, the case that the North Carolina case, because Justice Brown Jackson can weigh in on that. But can you just think and imagine what's going to be like when you can hear some of the conservatives saying, it's time we did away with this, and it's really discrimination and we shouldn't have it. And then hearing Justice Brown Jackson weighing in and saying something like, well, I'm an affirmative action baby. I benefited from this. And without it, I doubt that I would even be sitting in this room, or hearing Justice Sotomayor weighing in and talking about how affirmative action impacted their lives and improved their lives. So it's going to be, I would love to be a fly on the wall and hear the discussion that goes on there. And I wonder what Clarence Thomas would say, because he was also an affirmative action baby as well. And what is he going to do on that? Or will he remain silent? So we won't know until someday when they retire and someone writes a book and talks about all this.
Right.
But generally, they don't disclose any of this. But I would love to hear it. And I'm so counting on the three liberals to really push back on this. And maybe they will be able to change the hearts and minds of some of these justices.
Let's hope. And yeah, to be a fly on the wall for a lot of these cases would be really interesting.
I think he put a question in the chat, though, if you could read it in the chat.
Let's go. He says, to what extent do the evolving powers of state legislatures tend to depend on the subject matter of specific Supreme Court decisions? And also, with respect to one's moral and political views, what similarities and differences do you see between the appropriate actions of a Supreme Court justice and a legislator?
Well, the only thing, and I want to stress, I'm not an expert in any of this, but legislators make laws, respond to what their constituents want. The justices, their job is to interpret the laws to ensure that how they're being implemented or even written is constitutional. So they're very, very different functions. Once the court, however, weighs in and says, this is constitutional, it is okay to have race as a factor in affirmative action, then that in effect becomes the law of the land. Conversely, when the court says, no, race can never be a factor in admissions ever because it violates the Equal Protection Clause of the 14th Amendment, therefore it is unconstitutional, that becomes the law of the land. So they just have very, very different functions. And Tony, I don't know if I've answered your question, but I don't see the conflict, but that's the check and balance. That is the check and balance. So, and the legislature can act, the Senate, the US Senate, they can enact federal laws that can be different from what the court has said, as long as that law they've enacted is still constitutional.
And I think that's, and I do hope that answered Tony's question, but it does bring up an important point. In the Dobbs case, for example, and we know this is being discussed, is that Congress can legalize abortion by passing laws that then become the law of the land. So it
Right.
is a very important role in balancing off an almost out of control court. I'm tempted
Right.
to use that term.
But here's, so that's a really good point. So if you look at Dobbs, The Supreme Court did not say that abortion is unconstitutional. What the court said is that the decision of Roe is they just basically invalidated it and said, we're just going to leave it to the states. They're saying basically the Supreme Court shouldn't weigh in on that those are issues that the states themselves should decide. So the states are doing that. And immediately, at least 13 states went ahead and severely restricted a woman's right to choose. So you heard Lindsey Graham recently say, if the Republicans gain control of the Senate and the House, what they want to do is have a national ban. So have a law that sorely restricts a woman's right to choose. And they can do that. There may be challenges to it after that, but that's their prerogative. So basically the court didn't outlaw or ban abortions. It just said that the Supreme Court has no right to say that, to tell the states what to do. So they're leaving it up to the states, and it's a big mess.
Yeah, thank you for that clarification. That was good. Kendall Stansbury, if you'll unmute yourself and come on aboard and ask your question.
Okay, Judge Cordell, as a former judge, what do you think of some of the reforms that have been proposed to kind of address the ideological imbalance between the Supreme Court decisions and, public opinion?
Yeah. It's a really good question, and thank you for the question. There is a lot of talk now, and there are many academics who are writing about changing the U.S. Supreme Court, and I mean some radical changes. In my view, it is absolutely time to take a hard look at the Supreme Court because I believe it's broken. It is a politicized, weaponized institution, and we need to change it. And so there are many ideas about ways to change it. So one of the ideas is that, first of all, there should not be lifetime tenure. I'm in favor of that. I believe that when you give these justices lifetime tenure, they can go rogue. And we're seeing it now in real time. And I think there should be absolutely term limits on justices on the Supreme Court, and in fact, throughout the federal system. All federal judges, be they trial judges, circuit or appellate judges, and Supreme Court justices have lifetime tenure. So I would change that and make it the same as with the state courts, where all state court judges and justices have all across the country have term limits. The second is to just change dramatically the shape of the Supreme Court. There have been some suggestions to make it maybe as many as 50 justices who rotate in and who decide cases when the cases are in their geographical part of the country. So you'd have, if there's an issue coming up out of New York, then there would be justices who were from that part of the country who'd be looking at that issue, and vice versa for California or out here in the West. And so it's talking about expanding. I'm talking about expanding the U.S. Supreme Court, but also perhaps even expanding just the federal judiciary. So let me just tell you that in 1990, Congress expanded the federal courts, and they added 11 seats to the appellate or the circuit courts and 61 seats to the district courts or the trial courts. And before that was 1990. In 1978, Jimmy Carter, he signed the largest judiciary expansion in the federal judiciary in history, and he created 150 new judgeships. So there is a recommendation now, and this just happened last year, the Judicial Conference of the United States. This is a nonpartisan policymaking body for the federal courts. They have recommended that Congress create 79 new judgeships. And yet there are some people who are saying that's not enough. This should be expanded much, much more in order to get away from having people be these hyper-partisan judges who are loyal to whoever it is that appointed them. And in this case, we're talking about Trump. And basically their loyalties, what we're seeing with, for example, the Judge Cannon, who's dealing with the whole classified documents issue, she's basically loyal to Trump, and I think her loyalty outweighs her commitment to the law. So those are some. If you want to read more, you can also, there are a lot of scholars, legal scholars, who are now writing about this. And I think this is starting to really get some traction, that something has to change. We can't keep going like this.
I'm going to let you go soon because you have to zoom up to Sacramento to get this award. On that list of possible ways to amend the court itself and change the court, one thing that could be done right now without too much controversy, I think, is Congress has the authority to establish a code of ethics for the Supreme Court that applies to all the other federal courts. As you pointed out earlier, Justice Thomas, yes, refused to recuse himself. Congress could pass a law to require that, could they not, tomorrow?
Absolutely. So as I've written in my book, judges around the country, the state court judges, have to abide by judicial rules of conduct and ethics. The federal courts also have those kinds of rules, and that's for your trial judges, appellate judges, but not for the Supreme Court. They have no code of ethics or code of conduct whatsoever. So as a result, they can do what they do when they want to do it. That issue has been raised, and there is some attention now being drawn to why don't they have rules of conduct and ethics as every other judge and justice in this country does. And they have no disciplinary body. So if they do something wrong, so what? So that as well is starting to change. So again, gaining traction. So you have people who serve for life with no rules of conduct, no rules of ethics, and they can recuse themselves or not, however they want to do it. And there really are no repercussions. That people are starting to understand and believe that, as I do, that's absolutely wrong. And we really need to make that change as well. I hope that before we go, we do talk about the gay rights case that's also on the agenda.
Yeah, I still have that here, and we were getting short on time, and I wanted to get to our listeners, but let's talk about that. There's a couple here that somewhat related. One's called 303 Creative versus Elena's, and Yeshiva University versus Yeshiva University Pride Alliance. And this is going back to basically religious rights being pitted against LGBT rights.
Well, actually, it's a little different. And I just want to talk about the 303 Creative LLC versus Elena's. So that case is not about religious freedom. It's not an argument, well, I don't support same-sex marriage and it's against my religion. And that's not what this case is. It's about freedom of speech, freedom of expression. So this is a woman who has a website business. It's open to the public, and she has gay clients, no problem, but she refuses to design websites for anything to do with gay marriage. So, and she claims that if she had to do that, that would violate her right of free speech, that she selects her customers based on the message she wants to convey or endorse. And she doesn't want to convey to anyone because she designed a website for same-sex marriage that she supports it. So she's saying, I shouldn't have to do that. And so my counter to that is that means if the court says, yeah, you're right, that violates your freedom of speech and you shouldn't have to have gay couples as your customers, but everybody else is fine. If the court decides to do that, if the Gang of Six decide to do that, what they're saying, I think, is that if there were a white supremacist who had a business that was open to the public, that person, and I wouldn't wear white supremacist on a shirt, but let's say that's what his belief is, then he could deny services to people of color, because if he served them, if he had them as customers, that would send a message that he endorsed people of color or their right to exist, and he didn't want to do that. So I am very concerned about the message that this court may send. And again, it's not based on religious freedom, but on freedom of speech. So if they rule this way, we're going to have some serious problems with people being denied service just because of who they are, and finding that who they are is outweighed by a person's bias, by a person's prejudice, by a person's bigotry. And that's going to be yet another problem. Now, I don't know how this court is going to go on that issue. We do know that there are some of the justices on there are religious. I think there are a good number who are Catholics, so I don't know
Yes.
what that says about attitudes toward the LGBTQ plus communities. So that's just another one to keep our eye on and to be concerned about. Very concerned.
Yes, indeed. And we're coming up. I promised to get you on the road by 7:55 so you can go get another award. So I'll give you the last minute or whatever time you want to take to talk about the state of justice here in the United States at this point.
Sure. And thank you so much for this conversation and for people listening in. It's important to talk about these issues and to have sometimes uncomfortable conversations so that we can stay informed. And that's what your program does. It just keeps us informed. If people want to know more about the legal system in general, I encourage people to read my book, Her Honor, where I talk about the legal system in our state courts, in which every year 80 million new cases are filed in our state courts in this country,
Wow.
far more than in our federal court system. But if you want to understand how something works, you can read this book, but it's important to understand how things work if you want to change them, if you want to enact policies. You can't do it unless you have information and understand what already exists. So I am appreciative of the time to talk with you, Paul, and let's just stay ever hopeful, keep our fingers crossed, and we're going to be stuck with these justices for quite a while,
Quite a long time.
many years. And let's just hope that somehow these three liberals can really perhaps move some of these, just two, we only need two more justices to be more sensible and less, and you called them activists, because I described myself as an activist when I was on the court. My definition of an activist is you respect precedent, you respect the rule of law, and in addition, you do everything you can to improve the legal system. They are activists, but I think in the pejorative sense, in the negative sense, where they are going rogue, they are violating all the rules regarding precedent and just doing whatever it is they want to do. So that's the activism that in the past conservatives have decried and said, oh, this is awful. And this is exactly what this court and other conservatives on the court have done. They have been activists in a outlier sort of way. And it's my hope that these justices, these three women, will step up to the plate. I know they will do that, but hopefully change the minds and hearts of at least two of these justices on these very, very important cases before the court.
I share that hope. Thank you so much, Judge LaDoris Cordell, for spending some time with us this evening. I got a lot out of it. I hope our audience did. Thank you all for attending tonight. Thanks again to Sean for operating and steering the Zoom bus behind the scenes. We'll be back next month. I'm not sure what the program's going to be, but we'll be back and have some more conversation. Judge Cordell, thank you once again. Good night.
Thank you. Good night.